Hi officers, how's the Josh? The topic of extradition is important for prelims. We can expect a question here, and this is important because this issue has been in news for many years now. For example, we have this topic in news in the context of Vijay Mallya, Nirav Modi, Mehul Choksi, etc. So this issue is regularly in news, and the possible question around this topic can be around this law of extradition which India has got. If there is any other possibility of getting a question asked, maybe some international convention or treaty or whatever it is, if there is a possibility of some other question, I am going to make a follow-up video. But for now, we can rest assured that one question on this topic is a possibility, and that question will most likely be from the provisions of the Extradition Act of 1962. Now, we have seen in the past in UPSC Prelims questions regarding laws, regulations, policies, and the details of these things are regularly asked. So the first thing UPSC can say is give you a multi-statement question. It can say that India does not have a dedicated extradition law, or it can say that extradition in India is regulated by the Extradition Act of 1956, or any other year could be given. So you need to remember that India does have a dedicated extradition law, and this year is 1962. So the first point that is important is that this law extends to the whole of India. It has been passed by the parliament and it covers the whole country. So states do not have any say when it comes to extradition. This can be asked. Next, we have the meaning of extradition offense. So this law can be invoked only when you have something known as extradition offense. There are two aspects of it. If India has got a treaty with some country, then the offense or the list of offenses mentioned in that treaty will be considered as extradition offense. Or if India has not signed a treaty with the country, but still that country requests for extradition, then only those offenses which are punishable by at least 1 year of prison under Indian laws will be considered for extradition. If there is any law in India, if there is any offense committed in India which is punishable by less than 1 year of imprisonment, that offense will not be allowed for extradition. Next, the extradition treaty includes the treaties made by India even before her independence. This is important. This law accepts extradition treaty signed by India even when it was under colonial rule. And then we have the meaning of fugitive criminal. This includes a person who is convicted under an offense, or even somebody who is accused of an offense. Okay, both accused and convicted persons can be extradited from India. Next, we come to the application of the law. So this law will be applicable only when an order to that effect is passed by the government of India. So this means that the states do not have any role in the implementation of this law. Next, where India does not have any extradition treaty with a foreign state, in that case, the government of India can pass an order to treat any convention, any bilateral or multilateral convention to which India and that foreign state are parties as an extradition treaty. This is an important point. So any convention to which India and the requesting state are parties, that can be considered as an extradition treaty between the Indian government and the requesting state. And the offenses which are specified in that convention will be assumed to be the offenses for which extradition can take place. The next is the request for extradition will be given to the government of India, not to any state, not to any other body, the government of India. And after the receipt of the request, the government of India will order a magisterial inquiry, and if the magistrate finds prima facie that the person is culpable, that person can be arrested. The next important point is that the fugitive criminal whose extradition India is seeking, for example Vijay Mallya, can be tried in India only for certain categories of offences. The first category is, of course, the extradition offense itself. The second category is any offense lesser than the extradition offense. And the third category is any offense for which Indian government has taken the approval of the UK government for the trial. So if the offense for which India wants to try Vijay Mallya is anything other than the extradition offense or is greater than this offense, the Indian government will want the approval of the UK government for that trial. Very important point can be asked. The next important point is that a fugitive criminal can be extradited even for offences which were committed before the commencement of this act, which is the year 1962. Next, the maximum duration of imprisonment is 2 months. That is, once a fugitive criminal is arrested, within 2 months, this person must be extradited. Otherwise, this person can be released by the government on the order of the respective High Court. The next point talks about the property of the fugitive criminal. So it means that if the central government wants, it can transfer the property along with the criminal to the requesting government. Also, the central government has got full control over whether it wants to accept the extradition request, whether it wants to do the extradition or not, because the law says that if the government feels that it is unjust or inexpedient to accept the extradition request, it can simply reject it. Next, if the government of India receives simultaneous extradition requests from multiple countries about the same person, it is the volition of the government of India to choose which country it wants to extradite that fugitive criminal to. And the next point says that there are certain restrictions on extradition. If the extradition request is for an offense which can be considered to be political in character, the government can reject the request. If the request is for an offense which is barred by time, the prosecution for which is barred by time means it has become too late to prosecute that person for that particular offense, the government can reject the request. And lastly, the same points that we studied in the previous slide, the fugitive criminal cannot be tried in the requesting country for any offense other than the extradition offense, any lesser offense, or the offense with respect to which the government of India has given its consent. So I gave you the example of Vijay Mallya and UK government. That same example holds good if India is extraditing any person to any requesting country. The next point is really important. It says that if an extradition request is received for a person who is already accused of some crime, some offense which he has done in India, and this offense is not the same as the extradition offense, firstly this person will be tried for this offense, and only after that trial is over, the punishment is served, will the extradition request be considered. This is point number 1. Point number 2, if this person is already undergoing a sentence, imprisonment, for any conviction, for any offense this person has committed, so first this sentence will be fully completed and only then will the extradition request be entertained. The next point says that there is extraterritorial jurisdiction for under this law. So it says that an extradition offense committed by any person in a foreign state will be deemed to have been committed by this person in India, and this person will be liable to be prosecuted in India for such offense. So this is pretty simple. Take the example of Dawood Ibrahim. Dawood Ibrahim plans, terror activities or whatever, conspiracies against India from some other country, okay, maybe Pakistan or maybe any other country. So this offense will be considered to be committed in India, and Dawood Ibrahim can be brought to India and face the criminal justice system. So this is the extraterritorial jurisdiction under this law, really important. And the next point says that the Indian government can of course reject the extradition request received by any country, but the government can, as it thinks fit, take steps to prosecute such fugitive criminals in India. So this means that, for example, Bangladesh or Sri Lanka or China or USA, whatever, any country requests extradition of some person to India, and India rejects that request. But for that particular offense which the person committed in Bangladesh or USA or whatever, for that offense, Indian government can prosecute this person in India. Okay, important point. The next point is really important. It is about death penalty. Now, if India is seeking extradition of a person for an offense, the maximum punishment for which is death in India, but the country in which the person is presently, death penalty is not there. In this situation, if that person is extradited to India, the maximum punishment this person can get is life imprisonment. Okay, very important. It's complicated, but it's important. So this means that if Vijay Mallya has done an offense in India which is punishable by death and has run away to a country where death penalty is not allowed, now that country extradites Vijay Mallya, but Indian government cannot, or the judiciary, the justice delivery system cannot punish Vijay Mallya by death. It will be maximum life imprisonment. Okay, really important point. The next point says that Parliament has got an important role here. Every order which is passed by the Indian government under this law must be issued, must be laid before each house. Okay, both houses. UPSC can say only Lok Sabha or only Rajya Sabha or something like that. So every order, okay, every single order which is passed by the government under this act must be laid before each house of Parliament as soon as is possible. There is no minimum or maximum time which must pass before the order is laid before the Parliament. So as soon as possible for the government, each order must be laid before each house of the Parliament. And the next point says that the power to make rules under this law is, of course, with the central government, but every such rule which is made under this section must be laid as soon as is possible before each house of the Parliament. So not just every order under the act, every rule also that is made under this act must be laid as soon as possible before both the houses of the Parliament. And the Parliament can suggest any modification, or it can even annul, it can remove, it can delete the changes, the rules or the orders that have been made. But even if the Parliament deletes or it annuls the order or the rules, their validity will not be affected. So this means that if the government does something under the act, it cannot be undone by the Parliament. And lastly, we have what is known as the schedule. This schedule lists the offences which are not categorized as political offences. Okay, so this means that for these offences, extradition can happen. With this, guys, we come to the end of this video. I hope you enjoyed it, and if you did, please don't forget to Lassi, which means like, share, subscribe and comment. All the important links will be given in the description. Thank you.